quasi-person approach to non-human animals and their legal status. I want to just say at the outset that this proposal of quasi-property, quasi-person, it's really a response or a reaction to what we might call or might see as the dominant thesis in animal law, that property is the problem for non-human animals, and that the solution is to move non-human animals somehow from the category of property to persons. So this is either moral persons, as in the work of Gary Francione, or maybe legal persons, as Steve Wise would have it with the Non-Human Rights Project. Now, I believe that both of these approaches grossly exaggerate what would be achieved for non-human animals with a personhood status. I think, that we have to kind of keep that in mind. But probably more problematically, realistically, only certain animals are going to be able to come in for this personhood status. So the ones that traditionally now are being tried for are apes, certain apes, elephants, and cetaceans. I think these approaches also mislead insofar as they suggest that property is the main problem for non-human animals. And I think that we need to be careful here because although property facilitates the exploitation of animals, I think Jess Eisen is totally right in her LEAP talk that she gave on February 24th to ask us to really focus on exploitation, because it's the exploitation of the animals that is the place where we should be squarely focused. I'm starting from the position that I think there's something wrong with accepting that there are only two categories for non-human animals, property or person. And here I count myself in good company with Manisha Deka, who gave the first LEAP talk on February 3rd. For those of you who are here for that, you will know that Deka's concept of beingness is meant to be such a third way. She criticizes personhood primarily for its anthropocentrism, which I agree with. But I think there's also a problem with insisting on personhood just as a matter of strategy, but also as a matter of principle. So let's start with that as a matter of strategy first. Okay, most people, judges and legislatures, are probably going to reject personhood when they hear it. Why? Because they're hearing human being. So there's this, what I've called, when I've written about this elsewhere, an outrage factor. Okay, and if we only have two options, we only have two choices, there's an outrage factor reaction to person, then we're going to be left with property. Property understood in a pure, unnuanced way. And this is exactly the space that the field for 30 years has been really eloquently describing as this hopeless, abject place. So just as a strategy matter, it seems like a bad idea to kind of, say, well, it can only be one of these two things, because if it's not persons, then we're going to end up stuck in property. But also as a matter of principle, historically speaking, we've got these splintered forms of personhood that are common. So splintered forms of personhood or quasi-personhood, they are have been shared. Married women have always had a form of legal personhood, traditionally a common law that was splintered in that way. Roman slaves had it as a splintered way. A splintered status doesn't recommend that legal status, certainly, but it does show us that it's possible for it to exist. And so non-human animals in that respect are like this. They're property with some rights, limited rights, as Cass Sunstein has emphasized in some of his work on non-human animals. Saskia Stuckey calls these simple rights, I've also referred to them as small r rights, and they are the rights of animal welfare and animal cruelty statutes that many of you are familiar with. I think the very important point to emphasize here is that if an entity has these rights, these simple rights or these small r rights, then they really must already be persons of some kind, just as a logical matter, because you can't have rights unless you're a person. So I think that it might be a good idea, instead of emphasizing non-human animals are property, we can say, look, they're actually already persons. So what does that mean? What does that entail? Well, then that means that we need to start treating them as if they are. And most importantly, stop exploiting them, because the exploitation piece of it is the important piece of it. I think this is separate and different than there not being property. Why? Because property itself doesn't entail necessarily exploitation and violence. It doesn't permit it or justify it, even if people sometimes act as if it does. And here I'm really leaning on the work of Manha Say, or MH, as some people here might know, MH, who's doing her SJD research at Harvard with Kristen Stilt. She's really looking at this point about property not itself justifying or permitting violence. It doesn't. And probably in the field, we maybe have made a mistake a little bit to kind of give up that ground. And maybe we should be reevaluating and stepping back a little bit. So what is the strategy here then? The strategy is to say that the quasi-personhood status could be augmented or added to include what Stuckey calls fundamental rights, or capital R rights. These would be then better able to protect against exploitation, where small r animal welfare rights generally are not able to do this, as we know, as history shows and as current practice continues to demonstrate. Why call it quasi then? Why insist on that? It's just to try to cue that what we're saying is not personhood as in human personhood. And I think that that's just important as a matter of strategy. But also a matter of principle in the sense, why? Well, because those rights for different entities, the quasi-entities, are not going to be the same across all species. They can't be and they shouldn't be. And I know Steve Wise does agree with this because he often says, we're not looking for human rights for chimpanzees, we're looking for chimpanzee rights for chimpanzees. So I think that there is an agreement there on that. And what we need to really be doing is working across species. But I think that what's really important, and something that I think Steve Wise's work is not acknowledging enough, is that we can't just be looking at the human-like animals. And here I'm certainly not in alone. I'm in very good company with people like Decca, Tammy Bryant, and others. I often say to my animal law students, I think all of us have a kind of paradigmatic animal in our heads. It's sort of the reason why you show up and you're there sitting in the class. It might be your dog or your cat, or it might be, a farm animal that you had an encounter with at a sanctuary, or a film you saw about a certain, like my octopus teacher, an octopus, or something like that. I'll just share with you so you know where I'm coming from. My paradigmatic animals are foxes and fishes. So foxes because of the Pearson book, and I'm wearing my little fox necklace. I don't know if anyone can really notice or see that. That's my and also fish, because the new historical project I'm working on is looking at how the capture rule in Pearson gets adopted in this fishing case in Canada, in the Supreme Court of Canada in the late 19th century. So for me, I'm really holding those animals in my head. And so a legal status for animals that is not going to work for fish, for instance, to me that's not going to be adequate. That's not going to be sufficient. And this is kind of a principle. I mean, it sounds a little religious, but it's a sort of this idea that, the least creature, the least of the creatures has to be included. And if your status is not contemplating that, or going to ever have any room realistically for that, I think that that's a problem. And I think we need to just be kind of upfront about that. I think fish are super interesting in this respect because we think of them as, a wild fish, but now of course fish are, there's more farm fish than wild fish. And so this is an animal that is bridging both the wild issue problems and environmental problems, and also the farm context. And obviously those also involve environmental problems too. Okay, now quasi doesn't necessarily mean lesser. This is a question and a point that sometimes comes up. It's a little bit like, a quasi judicial officer or something like that. That person doesn't think of themselves as like less good than a regular judge, but it's just different. It's a different role. It's really describing a kind of in-between space, a resembling, but not quite the same as. And the reason why I like it and I'm putting it forward is because it's a known legal category that lawyers are comfortable with. Also, importantly, it's intentionally a very thin concept. And here I probably haven't emphasized that as much as I need to in the things that I've written about this so far. And I would contrast here, or maybe there's a similarity here with Decca's concept of being. Being can be thick in the way that Decca wants it to be, which is, if you've read the book or you came to the talk, you'll remember the thickness, the content comes from embodiment, relationality, and vulnerability. So that's a very thick concept of being. You can also have a very thin concept of being. So, for instance, in Quebec, the Civil Code of Quebec gives for animals, refers to them as sentient beings with biological needs. Okay, so that would be an example of a use of being that's really pretty thin and that's not really importing a whole lot of content or a whole lot of protection. People have criticized it for just being symbolic, merely symbolic, and not importing a whole lot of content. If you were at the talk with Manisha, you'll remember that Doug Kaiser asked her, well, that thick content of embodiment, relationality, vulnerability, how is that any different from the way that humans too are also beings? And I took the answer to that question to be, yes, we are humans and non-humans. We are all those things. And that is a sense in which that's the contesting anthropocentrism aspect of that project. So I agree with that. But I think that just as a general matter, a legal concept does better to be thin and formal. Why do I think that? Well, because um, of disagreement over thick moral concepts in just that very generic philosophical sense that, it's hard to get people to agree about a thick content. And so thin and maybe better. Also, I think that thin for something like this is good because we're going to have a lot of variation here, depending on species and depending on circumstances. And like, we don't even know what the content, like, as scientific understandings improve and grow and change, we're going to be not knowing exactly what we're putting in there. So I think from the point of view of like lawyerly flexibility, thin, it may be preferable. So, okay, so that's the quasi-personhood side of things. Now, in terms of um, property, we have to also think about this in a nuanced quasi way, I think. And so just as we think of personhood in quasi or splintered terms, we have to think of property as more than mere property. Okay, sometimes this is called property plus. I'm calling it quasi-property just to kind of match like um, the two sides of this. Um, and what will that do? Quasi-property, I think, is a good idea because it will really recognize the ways in which the law is already moving forward in some ways for at least some animals. Okay, and here, admittedly, we're only really talking about companion animals, but companion animals, like quote Chris Green here, who says they're the gateway. They're the gateway animal. Okay, all right. So companion animals, they can be victims of crime. They can be beneficiaries of trusts. They have best interests that can be taken into account in separation and divorce proceedings. If they're killed or injured, they can have a value beyond their monetary value. They can be included in domestic violence protective orders and come with a woman to a shelter when she has to leave other kinds of valuable property behind. Okay, and this is a list that I'm kind of shamelessly pilfering from a amicus brief that Justin Marceau I see is here. Kathy Hessler and I wrote for the Justice the Horse case. And we really ran with this idea, this more than property idea, to get the Oregon court to look at the victimhood status of the horse in that case. So these gains, and I think they're very real gains, and this is what I find so frustrating when I hear someone like Gary Francione saying, well, nothing, it doesn't mean anything. It's still welfareism. There's still property, you know, um, but why say that? Like, why not acknowledge the gains? Okay, because it's very discouraging, I think, to people to not have those things acknowledged. And why do we want to wash it out? Why do we want to lose these things? And I think that they do get washed out and lost with the property person's binary. It's making us think wrongly, in my opinion, that we only have two options. Now, interestingly, sentience really is the thing that makes non-human animals, insofar as they are property, a special form of property. And I've just sort of followed kind of the general line of thinking on this when writing about this. Now, Dale Jamieson's talk on February 17th, though, made me really kind of go, oh, okay, maybe I shouldn't be doing that. Because, pardon me, for those of you who were here for that talk, you'll remember he really emphasized, look, sentience is complicated for humans. So, we talk about how complicated it is to figure out what's going on with animals and whether they're feeling pain or not, but it's the same thing for humans. And so really, I feel like this is kind of a companion insight to the insight that came out at Manisha's talk also, because the embodiment, the vulnerability, and the relationality also true for humans. So I sort of feel like maybe, you guys can go back and like rename the talks in the series up until this time as "and humans too," because, it's really like sort of what's coming out from each of the talks. And, and in that sense, this is the contesting anthropocentrism project, and that's kind of nice. So I couldn't resist doing a little bit of a Dworkin's chain novel with the previous talks. And I'm sorry if you weren't here for the previous talks, and this is not really making a lot of sense. But for people who were, or if anyone's going to watch them afterwards in order, maybe it'll make more sense. But I was kind of thinking about Dworkin's chain novel a little bit here. Like it is up to you if you're the next person who's going. You got to like pick it up and carry it on. I hope that's not going to put too much pressure on Laurie Gruen and Alice Carey when they come for next time. But anyway, maybe don't tell them unless I don't want to put extra pressure on them. Okay, so I think in the balance of the time I have left, I'd like to just talk a little bit about personhood in other legal systems, because I do think that it's quite a dire situation for common law systems in Canada and the US, for very specific reasons. But I think that if we look in other legal systems, there's more promise there. And maybe that's going to bleed over. And if, people agree with that, and I think maybe that's where we should try to be focusing our efforts. But I'll just outline here a little bit some ideas about personhood and other legal systems other than the common law, and see where we go with that, and see maybe what insights this can yield. So here I'm thinking specifically of indigenous legal systems and also civil law systems, as opposed to common law systems. Okay, pardon me. I'll just take a sip. Okay, great. So indigenous legal systems recognize personhood for non-human animals in a very unproblematic way. Okay, there's no question that non-human animals are persons. Rivers, rocks, significant environmental entities are persons. That's just part of the cosmology. And it's been described by one Brazilian anthropologist as Amerindian perspectivism. Okay, and I think it's not a coincidence that countries that have significant indigenous populations are seeing the Amerindian perspectivism being constitutionalized in rights of nature, okay, in places like Bolivia and Ecuador. Kristen Stolt has written about this in the Harvard Law Review recently, and used the example of a Brazilian court relying on rights of nature and the concept of dignity from the German and Swiss constitutions, sort of kind of rolled all together to look at Brazil's right to an ecologically balanced environment. And then that was used for a case of a wild captive parrot. Okay. And just think about that, like the sort of serendipity of that and the unpredictability of those elements kind of coming together, like in the 1970s, when the dignity provision was put in the Swiss constitution, would they have any sense that in the 2020s, a Brazilian court would look to it and, I mean, to me, I love this example because it really does emphasize how we just don't know how the things that might look purely symbolic that are being included in various statutes or pieces of legislation might actually have legs. There's also the Estrelina monkey case in Ecuador now, as of the end of January, that has confirmed the rights of nature in ecosystems and biosystems also apply to individuals in nature. And I think Kristen and the Non-Human Rights Project were both involved in that case, although I don't know too many of the details of it. If we look also at some of the successful habeas corpus applications that have happened outside of the US, specifically in Argentina. So here I'm thinking of Cecilia, a chimpanzee, and then Sandra, the orangutan. Probably the people in the audience are familiar with both of those cases a little bit. In Cecilia's case, this was an example of a court referring to both Gaia, the Greek goddess of Mother Earth, and Pachamama, the Andean goddess of Mother Earth, and indigenous thought to ground the idea that Cecilia is a special member of the ecosystem that humans are obliged to protect. So that makes her a subject, not just an object, with rights to freedom and a dignified life. So that's really quite significant. The Sandra orangutan case is a little bit more problematic. She was declared a non-human person. There were some technical things. She did eventually get transferred to Florida. But, so at this point in the game, we might stop and ask ourselves, like, why is this working in some countries, but not in other countries. And I think that, it's interesting and to think about both the Amerindian perspectivism, because obviously that's influencing what's included in the Constitution. So you have this, actual textual language you can use. But there also may be the idea that um, in civil law countries, when people are hearing personhood, maybe they're not hearing quite the same thing that people in common law countries are hearing. And here, I would just want to say a little bit about this, and I should just say by way of background. So my legal training was originally in Quebec at McGill, where we learned both common law and civil law. And one of the first articles I ever wrote and published when I was a student, I was at Yale actually. I was there in the LLM program, and I wrote up this project that I had been working on when I was at McGill, which was about a judge who had this book collection and was doing these very interesting things with his private book collection. He was basically cataloging what I said were he had been the judge who had reformed the rules of civil status in the Quebec Civil Code, the Book of Persons. And I thought he was doing with his books a version of this Register of Civil Status. He was keeping material in there relating to acts of status, birth, death, and marriage of the people writing the books. Anyway, so it was this very cool thing. And I just was like, wow, that's so cool. It's like a blurring of like law and life and personal and professional and so on. Anyway, so I wrote about that. But what it caused me to do is look a little bit at the law of persons. And, that's something when you say to a common law lawyer or common law person in common law jurisdiction, they don't really know what you're talking about. If you say law of persons or droit des personnes, you can pick up a treatise and it'll be called droit des personnes. You can take a course in law school in Quebec called the Law of Persons. And that's the first book in the civil code. Most civil law countries will have this, a civil code that'll have the 3 books that are based on the Roman Gaian tripartite of property, of persons, property, and actions, or persons, things, and actions, I should say. And that first book, it's got like 300 rules on, it's very, very thickly populated. It's got all these rules about how to change your name, your domicile, your residence, your sex designation, your consent to bodily treatment. It's got all these things that are gathered together under this sort of idea or this concept. There's many, many provisions relating to natural persons, and then it switches to artificial persons, which are clearly contemplated to be corporations, but the word corporation is not actually used. And so that's very interesting. And, I remember being taught this when I was at McGill by one of my teachers there named Richard Yanda. And he would say, like, it's not, artificial person, it's not all of that space is not all taken up by corporation. There's also, other room for other artificial persons. And so when someone hears person, they're not necessarily going to think human being. In fact, what they're going to think is, do you mean natural or do you mean artificial? And so if you're kind of hearing that, there's probably more room for the non-human animal example to get in there, because you're kind of like, oh, where do I put that? And civil lawyers are very trained to it's very conceptual. It's very like category kind of driven. And so they'll want to know where to put things, and they'll think about non-human animals in that way. Now, so anyway, that's just kind of it's pretty speculative, really. I mean, I don't have any proof of this, but that's what my thinking as to like why it is that this is working maybe in some places and not other places. So my quasi-property, quasi-personhood proposal is not really for civil law places. I mean, I don't think they really need it, because I think that they're just going to work with personhood, because personhood for them it is more capacious. There's more room for artificial, natural, and sort of messing around with that. Plus, they don't like mixing categories, generally speaking, in civil law. Like they like to, it's I don't know why it has something to do with the conceptual, just way things are structured. So people, I don't think, would like very much a sort of mixed thing. But common law, we're total magpies, right? We're like always mixing and moving and shaking everything around, and nobody is really super concerned about purity or doctrinal purity, and certainly not in the US. So I think that so that's just a caveat, that the proposal really is kind of more specific for common law, not so much for civil law. And then civil law plus Amerindian perspectivism may help us understand a little bit some of these positive developments that are happening elsewhere. And maybe that could help us figure out how to bring them more into the US and Canada. You know, Kristen refers to David Boyd's book, The Rights of Nature, the Legal Revolution That Could Save the World. And David is Canadian. David talks about the Navajo Code and how that has a provision for plants and animals. I did write that down to tell you guys about that. It recognizes all creation, including animals and plants, have their own law. They have rights and freedoms to exist. Okay, so we have this in Canada and the US. It's a minor key as opposed to a major key. But, you know, the climate crisis, you know, it really probably is going to be moving the needle here and moving the minor to major. And so we can find different examples of this. I'm sure you guys probably, you know, because of your environmental expertise, can think of more examples than I can think of. But the one that leaps to mind for me is the Bill of Rights for Lake Erie. So this was a situation where people in Toledo in Ohio, they woke up, they were unable to drink their water because of the pollution in Lake Erie due to the CAFOs that are surrounding that part of the lake. And they were like, well, what can we do? It's right there. It's right on their doorstep. They want to try to do something. So it could be that rights of nature, personhood, maybe even personhood for non-human animals, this is going to maybe be like a little bit more of a gateway. But I do think that we shouldn't underestimate the recalcitrance that we've got going in common law systems when people hear person. And I'm sure Steve Wise would be the first person to tell you, like, yeah, oh my God, and it's driving him crazy. And this is the thing he keeps banging his head up against. Okay. So quasi-person, quasi-property then. Oh, and I'll just say, I think in the common law, you know, it's a bit different because when people hear legal person, I think what they think of is maybe corporation, then maybe they think ships or municipalities. And, you know, that's all good, but these are all pretty disparate examples that don't really sound much like each other. So there's not really a coherent category for this. They don't sound very much like each other, and none of them sound very much like non-human animals. So I think that's maybe a little bit of a problem. Quasi-property, quasi-person, then I think probably civil law systems could do without it. Those of the Amerindian perspectivism could do without it. You know, I think in Canada, we're like the US, that's a very marginalized thread or voice in the legal system. However, even in the common law, quasi-person, quasi-property, quasi-person is offered as a temper heuristic. Okay, and really what I mean here is that, you know, this isn't what we would want to use as the ultimate goal, okay, for non-human animals. And in some respects, it describes what they already have, but just kind of leaves room for development. But what it can do, I think, is consolidate gains on the property side, because there have been gains that should be, and those are like wins, like celebrate your wins, you know, consolidate gains on the property side, but also capture and encourage further growth on the right side. And so it's to try to say, you know, rather than insisting, okay, we got to look at this binary black and white, all or nothing, one or the other, maybe we're going to lose, maybe it's going to end up, you know, to say, okay, look, actually there's some nuance here. And in a certain way, this is strategic, but in another way, it's actually just also descriptive and accurate. So, so there it is. And I put it forward for your consideration. And I look forward to hearing your questions and comments.